Hi, this is Josh Blackman. I am the president of the Harlan Institute, and it is my honor to welcome you to the Harlan Institute ConSource Virtual Supreme Court competition. This is our Elite 8 round, our quarterfinal round. The top 8 teams have advanced, and today we're arguing the case of Espinoza versus Montana Department of Revenue. We have 2 teams today. The first team representing Petitioners is from Minnesota. We have Herbert and Hayat Muse. And the second team representing the Respondents is from Greenwich, Connecticut. We have Katz and Seldon, Salaj. They will each have time to present their arguments. Petitioner, you may begin whenever you're ready.
Mr. Chief Justice, and may it please the Court. The state of Montana initiated a program to fund private education open to the religious and to the secular alike. Religious parents used it to send their children to religious schools. Because of their choice, this program no longer exists. This constitutes a penalty based on religion because of an amendment that discriminates against religion. As this Court's cases show us from Herbert versus Werner to Trinity Lutheran, penalties based on religion and discrimination against religion run afoul of free exercise clause. Accordingly, this Court should now reverse the Montana Supreme Court's ruling and restore the program that existed before it in order that petitioners and other similarly situated persons may reap the benefits of this scholarship program. The framers of the Constitution were well familiar with religion in the public square. Religion was, in fact, seen as a crucial part of American governance and held a favored position in the minds of the framers, who hired chaplains to pray in Congress, declared holidays to give honor and thanks to God, crafted official documents with appeals to divine authority, and instituted laws based on religious morality. The framers expected the government to endorse religion on a non-sectarian basis and to protect religious exercise from the tyranny of the state. Indeed, a religious people supported by a government was seen as a critical part of the American experiment. This Court's precedents follow the reasoning of the framers. Herbert versus Werner explains that penalties on religion are just as invalid as prohibitions on religious exercise. Trinity Lutheran explains that state practices that discriminate based on religious status are one kind of an impermissible penalty. And this Court's Establishment Clause precedent, from Marsh versus Chambers to Zellman versus Simmons Harris, makes clear that the state may indirectly fund and indirectly promote religious education on a non-sectarian basis.
So, Counselor, let me, if I can just ask you a question. Let's start on the issue of standing. How exactly is Ms. Espinoza injured right now?
Ms. Espinoza is injured because she cannot obtain the benefits of the scholarship program that existed before the ruling of the Montana Supreme Court.
No, I get that, but no one can access the policy now, right? This policy is null; it doesn't exist. So, what's her injury right now? What's her harm right now?
Well, the injury isn't discrimination. The injury is the fact that you can't access the program. And the reason that the program is inaccessible, right? The reason the program doesn't exist anymore is because it was used to attend a religious school, right? So what's happening is the Montana Supreme Court is punishing Ms. Espinoza for her choice to attend a religious school, for her choice to send her children to religious school.
I get that, but what exactly was Ms. Espinoza's connection? Was she one of the taxpayers who was giving money to these funds?
Well, the way the program worked is that the Montana State Legislature instituted the program. The program provided tax credits to people who donated to certain charitable organizations, and then the charitable organizations then dispersed the funds to low-income parents, one of whom was Ms. Espinoza.
But, Counselor, Ms. Espinoza wasn't receiving the credits. She's not one of the schools, and there's no guarantee that her child will even receive the scholarship. I don't see how she's injured. What's her injury here?
Well, I guess so your first point, there's no technical strict guarantee that Trinity Lutheran, the school, would have received the benefits of the structural resurfacing program, but the court, accepted that case anyways. And as to jurisdiction, the court already considered a case that came to it in a virtually identical posture a couple of terms ago, and it granted the case, it vacated it, and it remanded it in light of Trinity Lutheran. So I don't think it'd be wise for this court to reverse stances on justiciability.
But wouldn't the ideal plaintiff here be the school? Right? Shouldn't the schools be the ones complaining that they're being denied funding?
Well, the school certainly has standing to sue, but so does Ms. Espinoza.
So then maybe we should dismiss this case. I mean, this just seems like Ms. Espinoza seems several layers removed from the actual issue here.
Well, I simply don't see it that way, Your Honor, because before the program was invalidated and absent the Montana constitutional amendment, Ms. Espinoza would be receiving financial benefit that she could use.
Okay, I get that. That's right. While this policy was in effect, there was, for argument's sake, discrimination. But today, right now, in 2020, we're all sitting here watching Zoom all day, right? This policy's dead. All parents in Montana now are subject to the same program. None. So, is there an ongoing injury after the Montana Supreme Court's decision?
Yes, there's an ongoing injury because just like before the decision, Ms. Espinoza was not able to access the funds. And you can't cure that injury by punishing everyone equally.
But it's
right?
leveling, the court has described leveling up versus leveling down, right? Why can't the court level down here?
Well, the court's addressed a number of cases where, institutions, cities, municipalities level down, right? So instead of opening, for example, pools to African American children, certain cities have just simply closed their pools in the period after Brown versus Board of Education. What the court said was that when there's evidence of a discriminatory intent, discriminatory reason for that leveling down, that it's constitutionally suspect. And we don't have to look far for the evidence. We just have to look to the Montana State Constitution, which discriminates against religious institutions by virtue of their religious status.
But should we really be reaching a major constitutional ruling on a program that doesn't exist anymore, right? I mean, why should we decide this when this program doesn't exist? Wouldn't the better vehicle be where this program actually exists? It's like, like a fictional program at this point. It's gone.
The program may be gone, but the injury to Ms. Espinoza is still very real. And maybe there's a cleaner, more perfect vehicle, but that doesn't mean that this vehicle isn't sufficient. That doesn't mean that there is an injury.
All right, counsel. So let's talk a little about the Blaine amendments. Do you think that Montana's Article 10, Section 6, is unconstitutional on its face or unconstitutional as applied in this situation?
It's certainly unconstitutional on its face, and I think as to whether it's unconstitutional as applied, the court doesn't really have to.
So if we declare the Blaine Amendment in Article 10, Section 6, Montana unconstitutional, does that mean it's now unconstitutional? I think it was in 30-something states. Are all those other ones also unconstitutional?
Well, not necessarily. It varies, amendment to amendment, right? No-A clauses are different. Some of the no-A clauses may draw distinctions based on use. Some of them may not. Montana's doesn't, and that's why we're not telling the court that it has to read Trinity Lutheran broadly, eliminate the sort of use status distinction that the court has hinted maybe it's drawing. We're just saying that in this case, because there's a clear case of status-based discrimination, the court should invalidate this amendment, and it can certainly evaluate other amendments as they come up on a case-by-case basis. And we would certainly hope that states would look to this ruling and modify their constitutions, to be in accordance with the principles of the U.S. Constitution if they're afraid of their constitutions being adopted.
All right, so let me ask you this question, right? I think I read from your brief that Trinity Lutheran is a very good case for you. I think that's a very good case. Let's pretend Trinity Lutheran hadn't been decided yet. It's only, 2017, 2018? It's a fairly recent decision. Were the Blaine amendments unconstitutional before Trinity Lutheran? Just pretend we don't have... These Blaine amendments are 100 years old, right? Let's just pretend we haven't gotten to Trinity Lutheran yet. Could you argue that Blaine amendments are invalid under the pre-Trinity Lutheran jurisprudence?
Sure. I think all you need is Herbert versus Varner, which says that when you penalize religion and when you force people to choose between receiving a benefit and between the exercise of their religion, that's just as good as a direct prohibition on religious exercise.
I mean, counselor, we got to talk about Smith, don't we? Right? I think Herbert stood for some time, but I think the Smith decision largely, it didn't overrule it. I'll give you that, but it certainly weakened it. right? It certainly modified the court's approach to free exercise. How do you reconcile Sherbert with Smith in that context?
Well, the key thing to understand about Smith is that Smith modified Sherbert in certain contexts, right? So when you're seeking an exception to a neutral and generally applicable law, generally speaking, you're going to fail. That's the holding of Smith, and that seems to contradict Sherbert, but that's not what we have here, right? Petitioners aren't going to the court and saying, "Hey, we want an exception to this neutral law." Petitioners are going to the court and saying, "Hey, we want to be treated equally in the eyes of this discriminatory law." So for that reason, I just don't think though Smith is particularly.
So you think that after Sherbert, at least it was a 30-year run before Smith, the Blaine amendments were unconstitutional?
Well, of course, I don't think you need the Supreme Court to say Dixit.
Oh, I know, but were there any challenges to Blaine amendments during? I mean, I'm not asking you. Maybe you don't know, and actually, I don't know the answer either. But I'm not aware of any Supreme Court decisions that said the Blaine amendments are invalid in that 40-year span. I mean, that. In other words, what I'm trying to get at is these are 100-year-old provisions, and if the Supreme Court had reached a result that rendered these things unconstitutional, we would know about it. Like it would have made a big deal, but the Supreme Court, to my knowledge, has never even considered the no-aid clauses or has never decided they're unconstitutional.
Well, part of that, I think, is because you have this long period of time, really from the slaughterhouse cases in Crookshank up to really Viacqua versus Hopkins, of massive Supreme Court deference and non-intervention.
I'm with you, but let's start in the 60s, right? Let's just say Sherbert was, 1964? Might be off by a year or two. Is there anything since Sherbert that would suggest the Blaine amendments are void?
I think a lot of the language in Locke versus Davey is helpful.
Okay.
And I think other cases, Church of Bukumi Babaluaye, for example, are suggestive of the invalidity of the Blaine amendments. But to reach, I think, your underlying point, I don't mean to be presumptuous, Your Honor, but I think the point you're making is that these amendments have been around for a long time, and that this court often gives certain weight to longstanding historical practices. And while that is true, simply because the court gives weight to something doesn't mean that it's an inexorable command, right?
Can we rule in your favor without declaring the Montana Constitution void? Is there any way we can rule for you and leave the no-aid clause in its place?
Well, I suppose you could send it back to the state Supreme Court for a certification regarding state law as to whether or not the no-aid clause does indeed prohibit the scholarship program as it existed.
I think that's an easy. I mean, I guess we could, but that's an easy question. It does. It says no aid. It's pretty clear. In other words, the only way can we reverse the lower court without setting aside the Montana Constitution, Article 6 or Article 10, Section 6? Is there any way we can do that?
Not that we're asking you to do.
Okay. All right. Well, let's move on to Locke v. Davey. How do you think Locke v. Davey helps your case?
Well, the key thing to understand about Locke versus Davey is that it concerned a program that was very friendly towards religion, that allowed scholarship funds to be used to attend religious schools. But it just stopped short of allowing funds to be used to attend schools that offered clerical training and education for ministerial vocations. Mm-hmm. And that's just very night and day difference from the case that we have before us, because the Montana State Constitution doesn't care if you're attending a religious school. It doesn't care if you're attending a religious school that teaches an entirely secular curriculum. So long as the school is controlled in whole or in part by any church, sect, or denomination, you can't receive any direct or indirect state aid.
All right, let's talk about, and I think that's all good. Let's talk about Trinity Lutheran for a second. What exactly was the benefit provided to Trinity Lutheran in that case?
Well, Trinity Lutheran sought a reimbursement for the expenses that they incurred when they resurfaced their playground using recycled rubber.
Right. The tire scraps. Can't we limit Trinity Lutheran to the fact that tire scraps promote public safety versus, in this case, you're funding a religious school that might provide Bibles to students? Can't we draw a distinction in that regard?
Well, that sort of narrow distinction isn't something that the court often does. You can look back to Brown versus Board of Education, which expressly limited itself to segregation in the field of public education. But that didn't stop the court from issuing a number of often per curiam unsigned opinions years after Brown, saying things to the effect of, this instance of segregation outside of public education is unconstitutional. See Brown versus Board. So the thing about Trinity Lutheran is that even though the facts may be different or there may be distinction, the logic of the holding can't properly be limited to Trinity Lutheran. But even if it could, we're still dealing with a constitutional amendment from Montana that would prohibit the sorts of programs that we saw in Missouri, that would prohibit indirect aid for pencils and erasers to go to schools and benefit schools that were controlled in whole or in part by some sort of religious entity. So
okay, Counselor, you have about 2 seconds left, so you want to just finish your sentence.
Even if that distinction was tenable, the Montana State Constitution is still overbroad.
Okay, thank you so much. We now have 15 minutes from the respondents. You may begin whenever you're ready.
Good afternoon. May it please the court. The question presented before the court today is whether or not the state government has to provide benefits to those who donate toward a religious education. The respondents believe the main delineation that needs to be made in this case is a common good versus a sectarian education. Cases like Tilton v. Richardson, Everson, and Trinity all provide cases in which a common good was being funded or appropriated funds toward by a state government. In Tilton, funds were appropriated towards buildings and was deemed okay in the eyes of the law as long as these buildings remained not used for a parochial purpose. As long as these buildings were used for a secular purpose, they were okay. A provision was added to this law which stated that 20 years after the appropriation of these funds, they could be used for anything: churches, religious education, etc. The court ruled that this was an unconstitutional addition. It stated that as long as the government was appropriating funds toward a sectarian purpose, it was in violation of the First Amendment. Everson provided a secular service, busing, which was allowed in the eyes of the law as it was, of course, secular and did not fund a sectarian purpose. Trinity Lutheran, as stated by Your Honor and the Chief Justice Blackmun, playgrounds with repurposed rubber chips is a public safety concern and falls in line with the child benefit theory pioneered in Cochran v. Louisiana State Board of Education. In addition, this ruling in Cochran was for books, textbooks, which were, of course, secular. A math textbook or a biology textbook in some cases is a secular purpose. This was also pioneered in Board of Education of Central District v. Allen, in which, again, secular textbooks were proven to serve a secular purpose and were therefore allowed in the eyes of the law.
Okay, Counselor, let me, if I could just interrupt you for a second. Let's start with Trinity Lutheran. I pushed your friend on the other side, Mr. Herbert, on this quite a bit, but I think Trinity Lutheran is a bad case for you. How do you reconcile your Blaine Amendment, Article 10, Section 6, with Trinity Lutheran? That's my question for you to start.
I mean, if you look at the facts of both cases, the cases are not similar in the slightest. As my co-counsel said, Trinity Lutheran concerned a rubber bound on a playground, which is a common good under the child benefit theory pioneered in Cochran, and doesn't advance any sort of religion. If you look at the case at hand, this tuition would be going towards schools which has religion infused in their curriculum. Most of them, I believe, start their days with prayers. They require that their students take Bible classes. And it's really just the mission statement of Stillwater is to, I believe, instill its students.
Okay, so I get
Christ-centered education.
Counselor, if I could just interrupt for a second, I get that the facts are different, but the holding of Trinity Lutheran was perhaps broader. The court said, and this was Robert's opinion, that you can't discriminate on the basis of religious status, right? Religious status. That was the word that Roberts used, religious status. Isn't that exactly what the Blaine Amendment is doing? Discriminating on the basis of religious status?
So if you look at this case in particular, it's not religious status. It's not because Espinoza is Christian that she is not getting the money. If Espinoza wanted to use get a scholarship towards a private institution that didn't teach religion, that would be okay. It's not simply because she's religious. It's because the money would be used to further religious education. And
let me just rephrase your statement if I can for a second. If this was a private school, the money can be given.
If it was a private secular school.
A private secular school, money can be given. But if it was a private religious school, the money can't be given. Right? I mean, that's what I think what you said. But that's religious status, right? That's the key word in Trinity Lutheran. I mean, how do you square that?
So it's not because the school itself is religious. So let's say if the school was owned by, let's say if there was a private secular school that was run by people who were affiliated with the Catholic faith, and they didn't teach their religion in that school, that would be okay. It's because the school is it's a religious activity that the school is promoting. And the state should not be compelled to support religious activities if it goes against their own anti-establishment.
Well, let's talk about Justice Gorsuch's concurrence in Trinity Lutheran. Where did Gorsuch disagree with the majority in Trinity Lutheran?
I am not sure, Your Honor.
Okay. Well, I'll help you a little bit. Justice Gorsuch described the difference between religious status and religious use. So I think what you're saying is it's not the fact that Stillwater was a religious school, right? It was the fact that they were advancing religion. Is that sort of what you're getting at?
Correct, Your Honor.
I don't really get that sort of distinction. What kind of religious school does not advance religion? Isn't the purpose of a religious school always going to be to advance religion? Like, how do you distinguish between religious status and advancing religion? They seem to be very closely related in my mind.
Well, as you mentioned, Your Honor, and I think it's a brilliant question. That is.
You don't need to suck up. It's okay.
No, I agree, and it's a problem that the respondents have faced going forward. It is a difficult delineation, and it's one that is difficult to call upon precedent. But in looking at cases like U.S. v. Nyquist, where the court ruled that, quote, a religious education is as much akin to a religious pursuit as it is an educational endeavor. Most religious schools, if not all, as my co-counsel mentioned, this very statement at the Stillwater Christian School is to equip students the tools for education through a Christ-centered education. We do believe that religious schools that do promote a religious identity or do instill religious values in students should not be eligible for government aid, as the state of Montana does have a historical and substantial interest in maintaining secularity in their government. If you look to Madison's memorial and remonstrance, which is, of course, a dispute with Patrick Henry, who proposed a bill which stated that a property tax would allow for a payable fund towards Christian teachers in the Commonwealth of Virginia, he said that the metes and bounds which maintain each department of power in our country must be invariably maintained. And he cited that religion itself was a department of power. He stated that if religion could not endorse itself and funds itself, then it should not exist. And the use of powers that be in the planet of the earth, as he stated, things that were not extra powerful or omnipotent like God, should not have influence over religion and religious identity. We employ the same line of reasoning when it comes to these cases. If you look at... And
I think your colleague had his hand up a minute ago. I'll make sure we get both of you in. David, did you have a point you wanted to make?
Yeah, and just kind of adding on to that, and I think the real delineation you see between religious purpose and religious status is in Tilton. So Tilton was a religiously affiliated school, but the state was allowed to give them money for something that they knew was going to be secular. So at first they knew that the buildings that were going to be constructed, they said that these buildings have a secular purpose. So a religious institution would be allowed to receive the aid if we could be sure they were using it for a secular purpose. It's only when they had the 20-year rule that afterwards, after those 20 years, it wasn't going to be necessarily a secular purpose anymore, that it was run afoul of the establishment clause.
So let me ask you a question. This is for either one of you. What happens if Stillwater said, you know what, getting this money is really important to us, so we're going to abandon our Christian identity and we'll become a strictly secular school? Could they have gotten the money in that case?
Yes.
Don't you see the problem with that answer, though? I mean, I think you answered the question candidly, but if you have to abandon or renounce your religious character to get the money, then that's a form of discrimination on the basis of religious status. In other words, the only way to get the money is to abandon your religion, right? They're stuck. The only way to get it. Yes, David, I see your hand.
So actually, let me kind of bring that in with a more moderate hypothetical. If Stillwater Christian High School said, okay, this money is incredibly important to us, so therefore, we're going to report to you with whatever accounting procedure we want that we are only using it to fund the secular side of our education, right? That they were only going to spend it on math textbooks or physics textbooks. Then that would kind of be leaning more towards okay. But the only issue that the respondent sees with that as well is that kind of runs afoul of the third prong of the Lemon test, which was, in which way can we do that doesn't have the government excessively entangling themselves with the religious institution?
Right, no, I get that, but other states don't have the Blaine Amendment, right? There are 20-something states that don't have Blaine Amendments, and they manage just fine, right? They have voucher programs that can fund religious schools, but only fund, physics textbooks. Why can't Montana do the same, to have a program with not excessive entanglement, but some guidelines of how the money is used? Why would that not be an option?
Well, this falls between the room for play within the joints, which is established in Walsby tax community of the city of New York, and ultimately it is a federalism issue. This is an issue in which the state believes it has a historical and substantial interest in preserving this secularity to a degree which is more than what is required by the free exercise and the Establishment Clause. And we believe that the court, in looking at this, should only have to rule on whether or not this is a constitutional application of the Montana State Constitution, which, of course, the petitioner has disputed. However, in looking at the line of reasoning and the precedent which has been established in cases like Tilton, Everson, Locke, Trinity, and the Board of Education v. Allen, this court and the respondents believe that the only application of this that would be applicable in the matter of Espinoza v. Montana Department of Revenue would be a scenario in which this school decided that they would only use these funds for a secular purpose. And in this case, we believe this violates the third prong of the Lemon test, which would require the state government to micromanage and to see where these funds were being appropriated.
And I think, I'm sorry to interrupt, but just your co-counsel is raising his hand. I want to make sure you're both able to get in. David, would you like to add?
Gallery view keeps shutting me
That's okay. That's okay, guys. Yeah, I know this is really hard. I'm not mad. You're doing very well. Go ahead, David, please.
Yeah, no, and if you want to look, I think my co-counsel covered kind of the very jurisprudence kind of answer to this question. But if you want to look at where that historic anti-establishment interest came from in Montana, you don't need to look any further than the Montana State Ratifying Convention, which I believe took place in 1973. At the convention, Delegate Burkhardt stated that the issue of church and state is an emotional issue for the public. And even Delegate Conover, who was representing a church at the convention, supported the amendment that's currently in the Montana State Constitution, saying that if we cannot support our private schools, then it's our fault. We are the ones that are running it, and we don't want anybody to interfere with us. So you see that Montana, in kind of both areas, both of them find this anti-establishment interest.
Well, maybe the people of Montana found this 30 years ago, but now religious institutions aren't so keen on it. I think most of the briefs filed in this case for religious groups opposed to Plain amendments, not favor them. But let me ask you this question, if I can. I asked your counsel, I asked your friend on the other side, do we have to declare the Blaine Amendment unconstitutional to rule in their favor? I think Curtis candidly said, yes, you have to declare it unconstitutional. Is there any way that we can rule in favor of Espinoza but leave your Constitution intact? In other words, is there a way that we could give Espinoza the relief she seeks while not altering your Montana Article 10, Section 6?
I mean, we are not here to represent Espinoza, but if you wanted a way to kind of do that, I mean, I think shutting the entire program down, as the state did, was kind of the best way to handle both sides of the concern.
No, but let's say we found that was discriminatory, right? And let's say we find that you can't shut down, you can't level down. You have to level up, right? Is there any way to level up without setting aside your state constitution? Article 10, Section 6.
I mean, I would encourage Espinoza to seek federal funding for her education.
No, I get that, but can we rule for Espinoza and leave your constitution in its current status?
I don't believe so, Your Honor.
Okay, that's your position. So the only way to rule for Espinoza is to declare your state constitution invalid. I think that's what you're saying.
Yes.
Yes, but the thing is that when you're actually looking at this, that this case can be easily decided without discussing the Blaine Amendment at all. I mean, if you look into the kind of precedent that backs up how these cases are usually handled, it's usually more about the application of the Blaine Amendment rather than the text of it itself. So, for example, I would point you to Locke v. Davey. The state of Washington's Blaine Amendment is very similar to that of the state of Montana, as it says no public money or property shall be appropriated for or applied to any religious worship, exercise, or instruction, or the support of any religious establishment. Yet, the Supreme Court in Locke was able to look at how the Blaine Amendment was being applied and saw that it was being applied constitutionally. Therefore, I think it would be wise for the court to exercise judicial minimalism, as it long-term has tried to, and look at the way it is being applied, see that it's being applied pretty much in an identical way to the way it was being applied in Locke, and therefore rule that constitutional under the federal constitution.
Okay, you have 15 seconds left if you want to wrap up. Or not.
I think that the greatest point that we are going to make, Your Honor, is the fact that you just have to have this difference between a secular use and a non-secular use. There's obviously a non-secular use here, and therefore it runs afoul of Montana's own historically backed anti-establishment concerns.
Okay, that's time. Okay, petitioners, you now have 5 minutes for rebuttal, and you can begin whenever you're ready.
Chief Justice, and may it please the court. Respondents raised several arguments as to why the invalidation of the Montana Scholarship Program did not violate the clause of the First Amendment. They are all unavailing. Primarily, respondents attempt to draw a distinction between this case and Trinity Lutheran by arguing that Article 10 was not an identity-based distinction, but rather a use-based distinction. There are several problems with this. The first problem we can see in Justice Gorsuch's concurrence in Trinity Lutheran, where he states, does a man say grace before dinner, or does he begin his dinner in a religious manner? And this highlights the problem with the identity versus use-based distinction, which is namely that it fails to be a distinction at all. But regardless, I don't believe today we have to reach a conclusion on whether a status-based or use-based distinction varies into whether it's constitutional at all, because we can see in Montana State Constitution that this is a clear case of status-based discrimination. Montana's Constitution says nothing about religious use. It plainly prohibits funding to any and all religious institutions, regardless of whether they teach religious curriculum, promote the practice of their religion, or otherwise use the funds in support of religious practice.
Okay, Counselor, if I could just interrupt you for a minute. So let's talk about the Gorsuch concurrence, right? It was concurrence. Only 2 people joined it. And there was a footnote. What was that footnote number? There was a footnote in Trinity Lutheran. I'm sorry, in Trinity Lutheran that Gorsuch didn't join. Did the majority embrace the Gorsuch position?
No, I believe it was. No, the majority didn't. I believe it was footnote 3.
Yeah, that was. I forgot the numbers. Footnote 3, right? Tell me about footnote 3. What was going on there?
Footnote 3 essentially restricted the ruling in Trinity Lutheran to the facts of the case, which was the playground resurfacing program.
Okay, so I'll just read it. It says, this case involves express discrimination based on religious identity with respect to playground resurfacing. We do not address religious uses of funding or other forms of discrimination, right? So I see footnote 3 is trying to limit it to a very narrow set of facts. And Gorsuch is saying it goes everywhere, Blaine amendments. But so how do you connect Trinity Lutheran, given footnote 3, to this case? Isn't there something else you have to do? Isn't there some other work you have to do?
Your Honor, while it's true that Trinity Lutheran was only about playground resurfacing in the immediate sense, but we could also look to, as my co-counsel pointed out, Brown v. Board of Education, where this court has also limited its holding to saying that in the field of public education, the doctrine of separate but equal has no place. But of course, that didn't stop the court from issuing a number of opinions saying basically the instance of segregation outside of schools is unconstitutional. See Brown v. Board.
Oh, I get that. No, I get we can extend it, right? So I think there's 2 arguments. One, does Trinity Lutheran compel your position, or are you asking us to extend Trinity Lutheran to support your position? Which one do you think this is?
I don't believe we're asking for a broader reading of Trinity Lutheran. We're simply stating that the logic of Trinity Lutheran is that status-based discrimination is unconstitutional. And the logic cannot be ignored simply because of the facts of the case.
All right, let's talk then. You have about 2 minutes left, about minute 45. Let's talk about standing for a minute. I'm still not exactly sure what your injury is, right? I mean, there are cases about taxpayer standing. There are cases about schools that are denied funding, and there are cases of people who are denied funding from the state. But your client is removed. She wanted to send her kids there, and maybe they'll get a scholarship, maybe they wouldn't. There just seems to be so much uncertainty. Why is your client having any sort of injury?
While there is uncertainty about whether they would receive the scholarship program, the invalidation of the scholarship program made it impossible for them to ever receive these funds. And I believe my co-counsel touched on this, but the injury is not disparate treatment. The injury is that the invalidation of the program made it so Ms. Espinoza could no longer receive funds to send her children to a religious private school.
But why can't the Montana courts just level down and make everyone equal and we don't have an issue anymore? No one's being discriminated against. Everyone's worse off, but there's no discrimination in the current situation.
Well, if we look to precedent, we can see in cases such as Palmer v. Thompson and Griffin v. County School Board, we can see that in matters of invalidation of entire programs, this court has looked to the intent of the invalidation. And if it was proven that the intent was discriminatory, then more than likely it would be ruled an unconstitutional invalidation. So I don't believe the invalidation of the program really has any effect on the ruling if we can prove that there is discriminatory intent. And that can be proven just by a simple look to Montana's Constitution, which signals solid religion.
Okay. We have about 10 seconds left, so okay. Thank you, Counselor.
So the state is not being forced to fund religious education. It is prevented from punishing people for religious choice.
Okay, very good. Right on time. Thank you, Counselor. Okay, now we have 5 minutes from the respondents for rebuttal. You can begin whenever you're ready.
I'd like to start with 2 quick points and then give it over to my co-counsel. The first thing is that the petitioners consistently argue that the state is not allowed to strike down this program after it has already occurred, that the very act of them, that it wasn't a neutral decision to get rid of the program altogether, but that in itself is discriminatory. So that I would respond with Justice Scalia's dissent in Locke. And there he said that Justice Scalia actually disagreed with the ruling in Locke. He thought that they had to be given a degree in devotional theology, the money to go get it. But he said there that the state could simply abandon the scholarship program altogether, and that would be a permissible course of action. So what I see is that that's exactly what the state's done here. And even those who hold that Locke isn't constitutional have held that that's an available path of action. So I think that trying to criticize that path of action has little ground to stand on if you look at the dissent in Locke. The second quick point I'd like to get to is that there's been a lot of dispute about the interpretation of Trinity Lutheran v. Comer, but I'd like to take it a little further back. As the respondents hold that we should go for a narrow interpretation of Trinity Lutheran in which it applies to playgrounds, which are a child benefit under Cochran's theory. But that precedent goes way back before Trinity Lutheran, as my co-counsel said in the beginning. Everson, buses, those serve a secular purpose. Board of Education v. Allen, textbooks, secular textbooks, those serve a secular purpose. Tilton, buildings for secular buildings that teach secular items.
So, Counselor, let me just read you a sentence if I can from Trinity Lutheran, right? Roberts wrote, "In this case, there's no dispute that Trinity Lutheran is put to the choice between being a church and receiving a government benefit. The rule is simple: no churches need apply." And then there's footnote 3. Yeah, I recognize footnote 3 limited it, but it seems a logical outgrowth, a logical extension of that sentence is Stillwater is being denied because it's a religious status. The fact that it's a religious status and advances religion, I think, is almost redundant. Of course, a religious school advances religion. How can you use Trinity Lutheran in your case? It just seemed too much tension for me.
I think the respondents hold that the biggest differentiation that you can make between Trinity Lutheran is that it's not because Espinoza is Christian that she's not getting the scholarships. It's because she wants to use it for a Christian purpose. I think the very
Counselor, come on, all religious schools, right? All religious schools of religious status are trying to advance religion. I can't think of a single religious school that has only secular instruction. I think that doesn't exist, and maybe it does. I've never heard of it. So, how do you draw this distinction?
So actually what you're saying there is true, and here's how the distinction could be drawn, is if the state had established a program that they could assure, we're not saying you can't give the money to a religious school because they're religious. You're saying you don't want to fund their explicitly religious activities. Once again, if the state wished to give textbooks that were secular and subjects such as physics or math to a religious institution,
but I don't
the
think
respondents would hold that's okay.
I don't think your state constitution allows it. As I read it, it's any aid to a religious institution. It's not for religious purposes. It's pretty broad. I don't think they can give a physics book to a religious school.
Well, once again, I don't think that a ruling on the Blaine Amendment here is required to decide the facts of the case. I think that that's simply a comparison you could draw. But if you look at the facts of the case, it very clearly is going towards a religious purpose. It's going towards a religious education, which, as you said, Justice, is inherently a religious endeavor. So I think that's where the line should be drawn.
Okay, and I think, Counselor, Sheldon, did you unmute your microphone? Yeah. And you have about a minute left if you want to come in.
The petitioners draw parallels to Palmer v. Thompson and just drew a parallel to Griffin v. School Board of Prince Edward County. And the respondents believe that these parallels are null. In Palmer v. Thompson, it was a segregation case in which they closed schools instead of integrating African American and white communities into the same pool. Griffin v. School Board was very similar. The county closed schools because they were forced to desegregate, and this was found unconstitutional. I think that legal precedent shows that segregation has no place in our Constitution, and the spirit of the 14th Amendment, as discussed in the book, The Spirit of the Law, the spirit of the 14th Amendment does not provide room for segregation in our country. The case at hand does not ask if segregation based on legal or religious status is not appropriate for the state. It asks whether or not the state should be compelled legally to fund a religious education, which, as you stated, is inherent with a religious institution. If these funds could be proven to go toward a secular purpose...
Finish your sentence, please.
If these funds could be proven to go toward a secular purpose, they would be permissible. However, we do not believe that if this distinction cannot be drawn, it is allowed.
Okay, excellent. Wow. That was really good. Really good. I'm not just saying that. I doubled my efforts at asking hard questions from last round. I actually went back and I looked over the oral argument from the Supreme Court, and a number of the questions I gave you came right from the justices, so I'm not that creative. So I a little Sotomayor, a little bit of Ginsburg, a little bit of Kavanaugh, a little bit of Gorsuch, a little bit of Alito in there, a little bit of Roberts. I gave you a little bit of everything. So they seem familiar. That's where they came from. This was fantastic. I'm impressed. This was hard, and I think you handled my nudging in a very, very good way. Sebastian, anything you'd like to add?
Yeah, I mean, you all made the Elite Eight for a reason, and I think it showed. Justice Blackmun asked a lot of really difficult questions. There were some that, honestly, I was sitting here thinking, like, I don't know how I would answer that. I don't know how I would begin to answer that. So
me neither.
You all showed a lot of talent and a lot of ability to think quickly on your feet. So well done.
Thank you, Sebastian. A lot of the questions I don't have answers to. I think the standing issue is really hard. I'm not picking a side, but I think it's a very hard standing issue because what the Montana Supreme Court did was tough. I think in this case you'd have to declare the Montana Article 10, Section 6 unconstitutional. I don't think you can rule for Espinoza without it. And there's some other really nuanced question I think you all took a position on. And that's good. Sometimes you have to take a yes or no. You can't do maybe. And once you get the yes or no, you just have to brace for the follow-ups. You know you're going to get slammed. The Trinity Lutheran footnote 3 issue is, I think, very difficult. I think about it quite a lot when the Trinity Lutheran came out a couple of years ago. It's in 2017. I think that's a hard issue to decide, and I don't have a good answer. Is Espinoza an extension of Trinity Lutheran, or is it followed from it? It doesn't really matter at this point. But I think those are not easy questions. Are there any questions from the four of you? You all did a wonderful job, in my opinion. Curtis, no? Hayat? Sheldon? David? Nothing? All right. Well, I will put this video on YouTube a little bit later today so you guys can watch and show it to your teacher if you want. And I'll try to get back to you maybe by tomorrow, maybe Friday at the latest, with our feedback and who's advancing. But I'm proud of all of you. And if you ever have any questions, you can email me about college or law school. I'm always here to help. Okay. All right. I will call this meeting to a close. Thank you so much. I think our next round begins around 90 minutes or so. So Sebastian, I'll see you later. Thank you.